the recording. Okay, so this is the lecture for segment 6 of the CRPD course, taught from a survivor psychiatry perspective. I'm going to start talking about CRPD process implementation and monitoring, and it's going to continue in segment 7, the next lecture. So today it's going to be, I'm using pretty much the same slides as I did in the spring, but I may do a little bit more that's not in the slides. So what we have in the slides is mainly general concepts related to implementation and monitoring, the CRPD text, what the text actually says is required from governments on the process aspects of implementation and monitoring, and civil society participation in both national level and international monitoring. So we'll explain what all of those things mean. Some people in the class are very extremely familiar with the CRPD committee's processes and with human rights reporting generally. Others probably have little or no familiarity with it. So I'm going to start out with some very general and basic things. And next lecture, I'm hoping to go more into some concrete examples. But this time, I think there's going to be time. I would like to go to the CRPD committee's website and go through with you some of, say, some of what the materials look like in the reporting process and in the monitoring process. So, okay, here we go on this is again like starting with some very general concepts that people need to know if they're not very familiar with how human rights works and what it means to say that states have obligations and how states are supposed to implement those obligations and what is done to monitor their compliance, and is there any kind of enforcement. So human rights treaties in national law. Human rights treaties, we know, are part of international law. Governments negotiate the treaty, governments can sign the treaty and ratify the treaty. I believe we talked about in the first lecture that a signature, if a government only signs but doesn't ratify, that does not legally bind them in international law to carry out the treaty. But once they deposit their ratification and commit themselves formally, they are bound in international law. But does that actually mean, what does that mean for the person with a disability in any particular country? Does that mean that since their government is bound to comply with the CRPD under international law, does that mean that you can actually go into court or go to whatever authorities and demand that your rights be respected and protected and fulfilled under the CRPD? Human rights treaties are double facing in this sense. They face towards international law with obligations. They're making formally their obligations to other states, to the international community. And at the same time, their obligations relate to what they must do in their own countries and often prescribe how they must change their national laws. So, and in general, it's a principle of international law that if a country that if a country has national laws that contradict the treaty, it doesn't excuse them from complying, and that's in any area of international law, including human rights. So a concrete example related to the CRPD that we're all familiar with, a country could not say, well, I have a mental health law that allows forced treatment. Therefore, the CRPD provisions obligating obligating abolition of forced treatment do not apply to me. They can't excuse them. The fact that they have that law, they still have the obligation under international law to actually abolish forced treatment. So in effect, if we understand international law to be superior, it means that they have to change their laws. They have to change their laws and their practices in order to comply with international law. And in fact, the CRPD directly requires states to change their national laws to eliminate any measures of discrimination based on disability. Where am I trying to go to? Okay. And we'll just go look at that for a minute. In Article 4, there's the obligation first to adopt all appropriate legislative, administrative, and other measures for implementation of the right. So they are obligated by the terms of the treaty to make necessary changes to their legislation in order to implement the right, and to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices that constitute discrimination. So if they have existing laws that violate the CRPD, not only are they not excused from their obligations under the CRPD, but they actually have the direct obligation under international law to change their national law to comply with the treaty. So they have the direct obligation to abolish their mental health laws. But what does that mean in terms of their national law? Because states, the effect of the treaty in a country's national law is going to depend on a lot of things, and states develop various doctrines to limit the direct application of international law in their national law and courts. One of those doctrines is, or one of the ways that different states may have a very different approach to human rights treaties and other international law, is what can be called monism or dualism. That's terminology used with respect to whether a state actually treats international law as being part of its national law, or whether they understand international law to be separate from national law. So the way that I've been talking up till now, showing that there's a question, really refers to the fact that although some states actually don't treat it as a separation, many states actually do. And I think I may not be being very clear about this, but monism, some states say, there are many states in Latin America that have the doctrine of monism officially, that they treat international law as being directly incorporated into their domestic law. And some of them even provide in their constitutions that human rights treaties will be accepted as part of the rights guaranteed to people in that country under the Constitution. So that's a very high level of acceptance of a treaty into international law. And in those countries, there should usually be some kind of process where a person whose rights are violated can go into the national court and demand that their rights be actually fulfilled. And the court will have to address that will have to adjudicate their claims under the treaty because it is treated as part of the national law. In other countries, you simply cannot do that because they have a dualistic approach whereby they treat international law as being completely separate from national law, and they do not consider that their domestic courts have any obligation to 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 people within their own country under national law just because they have ratified a human rights treaty. I believe Australia's approach is of that nature. They do not accept that. I may actually. I'm not entirely certain. I'd have to check, but I believe that. Well, maybe I won't say anything about any country, but you say Singapore's is like that. So thank you. I think it's also important to recognize that various countries that may formally take an approach that looks more like one, in practice might do more of the other. So the United States is an interesting example because in our Constitution, it does provide that the law of nations is a part of the national law, and yet there have been so many doctrines developed, particularly around the concept of non self executing treaties and whether there's a right of private action. And our government has always made a declaration to any human rights treaty to say that the treaty is non-self-executing, so that it would actually make it would mean that the government has to pass laws, international law, to put the treaty into effect, and the treaty in itself is not going to be something that the national courts will actually adjudicate on or will treat as part of the body of national law for the purposes of any enforcement of rights. So, and then in many countries, then in the United States, there's also been a doctrine developed that it's called in our country the Charming Betsy doctrine, after a maritime law case by that name. The ship was called the Charming Betsy. That to the extent possible, our national law should be interpreted so as to comply with international obligations. And some human rights advocates have attempted to use that to bring in human rights treaties. There's also the possibility of arguing international law and comparative law, how other countries are dealing with an issue, how the international human rights system is dealing with an issue, to as part of your persuasive argument to persuade a court that they should find the result that you're looking for, even though the court will not consider it a binding authority. So there's those ways that governments both limit how they deal with international law in domestic courts, and then also try to find ways of bringing it back in. And you will actually find some of these different doctrines across many states, irrespective of whether they formally have a monistic or a dualistic approach to international law in national courts. There's some interesting work on this whole topic that's being done. I believe it's by the International Law Association. If anybody here is interested in the sort of general question, and I think in relation to the CRPD, it means essentially that in some countries there's going to be both, there can be legal and there can be both legal and political obstacles, and both legal and political um, openness to the question of how seriously is the country going to take its obligations to implement the CRPD within its national law, especially in terms of what the courts can do, how the courts are going to treat the CRPD, but also in terms of how they understand their obligations to change legislation, the obligations on the legislative branch of government to take action to repeal what's inconsistent and comply with what's consistent. And we also see, we see the political aspects of there's the general political legal culture in terms of whether a country whether a government will consider that it has to somehow justify any departure from the CRPD, and how seriously they will take the CRPD committee's jurisprudence. And then there's the political culture in terms of how a government, how governmental decision makers or legislators want to address any particular issue, and even how courts want to address any particular issue. So if they consider that the status quo of forced treatment is something that they really accept, and they're reluctant to depart from it, they will try to find ways to reinterpret the CRPD in line with the results that they want. And this is what we see happening in various countries so far. And so this is why I would say we still haven't seen most countries even making a credible effort at complying with the CRPD in the areas we're discussing, credible effort being what I would consider to actually comply with the CRPD jurisprudence, with the CRPD as the committee has interpreted it. So let's take a look at what the CRPD says on national implementation and monitoring. We looked at Article 4. I'll just run through this slide and then we can look at it a little more closely. General obligations, not just in Article 4, but there are obligations, or there are general aspects related to implementation and monitoring in Articles 1 through 4 as a whole. We have in Article 2 definitions, and the committee has repeatedly criticized states that don't have a social model definition of disability. The CRPD in Article 1 does not actually contain a definition per se. It says persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis. And what the committee has really called attention to is the necessity for a social model definition that relates to the barriers people experience, rather than focusing on defining people according to impairments. And as I think we might have discussed at one point, the question of what it means that long term is in there, that's one of the reasons why I am reluctant to characterize this as a definition. It is not a definition. It doesn't say people with disabilities means. It says include. So it's possible to understand it as more inclusive. But for people with psychosocial disabilities, the question of what it means to say that a person has a long-term impairment is, it's really counter to what many people call the recovery approach in mental health, believing that we don't necessarily have to accept that the situation that a person is in now is going to be permanent. And also the question of whether we characterize the experiences of distress or altered consciousness as an impairment, and the question of experiencing barriers and experiencing severe forms of discrimination, and the question of whether of being discriminated against because somebody believes or perceives that you have an impairment, even if you don't experience it as such. It becomes very subjective and very political, even for someone else to say about a person that they have a mental health condition if the person doesn't experience themselves in that way. And so in any case, that's the criticism, and that's why I would hesitate to characterize that as a definition or to enact into law that specific language. But it's important to address the social model as part of the definition of disability, the definition of people with disabilities. And it's important to make sure that people with psychosocial disabilities are included in such a social model definition. So, law reform, repeal of discriminatory laws and practices, we looked at that under Article 4.1. Administrative and other measures. Now, in Article 4, it talks in 4.1a, it talks about adopting appropriate legislative, administrative, and other measures. And in B, it talks about all appropriate measures. I think it's important to not only focus on the legislature, to remember that, if the legislature is maybe politically stymied, or they don't want to be considered as adopting something politically unpopular, but maybe you have someone in the Justice Ministry or the Health Ministry that could interpret existing law and enact regulations or policies that would have the effect of moving us towards the elimination or abolition of forced treatment. That's something worth considering. What can the administrative branch of government carry out? And that's going to be something specific to any particular country. Also, consider if you have a federal state, what the national, it may be easier to do something at the national level or at a state or provincial level. And that's something also to consider. Where can you address the legislature? Where can you address the administrative branch of government at any level, even a municipal level, to the extent that a municipality would have power in the area that we're dealing with. Other measures would necessarily include judicial measures, and courts are a branch of government and have their own obligations under the CRPD to implement the right and to abolish the existing laws, to modify or abolish existing laws, regulations, etc., that constitute discrimination. So we could also look at access to justice in that light. The article on access to justice states parties shall ensure effective access to justice on an equal basis with others. And that's really focusing on access to justice in general terms, and equality and equal access in courts and other proceedings, related to the administration of justice, but it can also be thought of as suggesting a substantive component. I think that in the general comment on Article 12, I'm trying to find this, that there, well, I may not be able to find what I'm looking for now, but okay, that in this, that the access to justice has been effective legal representation has been identified in a problem as a problem and must be remedied, including by ensuring that persons who experience interference with their right to legal capacity have the opportunity to challenge such interference on their own behalf or with legal representation and to defend their rights in court. So that is really the committee bringing in a more substantive interpretation of the right to access to justice, to as suggesting a right to be able to go into court and challenge interference with your rights that the convention says that you have. So let's go back to the slides. Oh, and I will say also on access to justice that in the CRPD committee's guidelines on Article 14, there's some good material that is taken and quoted from the basic principles and guidelines of the Working Group on Arbitrary Detention, suggesting what courts can do to remedy both individual and situations of being confined and forcibly treated under mental health laws or in the mental health system. The committee also says that there needs to be a review process and monitoring of institutions, and that those measures do not constitute that this statement that there needs to be review does not constitute an endorsement of the involuntary measures. So there needs to be review in some sense proactively, and at this point, since there is involuntary commitment and involuntary treatment that's contrary to human rights, there has to be some process by which individuals can challenge it. And then what the Working Group on Arbitrary Detention material brings in is some suggestions of how courts can actually address these situations concretely, including some that would be collective remedies, systemic remedies, so that it doesn't have to mean each person whose rights are violated has to become aware of their rights on their own and come into court and individually challenge their detention. And I would say that document by the Working Group on Arbitrary Detention, the basic principles and guidelines that we discussed in context of Article 14, has some other good material if you want to look at the how courts could address and what courts should be encouraged to do in relation to implementing rights, particularly the rights under Articles 12 and 14. Obligations to address discrimination by private actors, that's also in Article 4. I mean, there's appropriate measures, including legislation, not only to modify or abolish laws that discriminate, but also customs and practices. So that's an obligation in effect to reach actions that are not necessarily undertaken by government, but by private actors. Here's the obligation to ensure public authorities comply to refrain from acting inconsistently with the convention, ensure public authorities and institutions act in conformity, and to take all appropriate measures to eliminate discrimination on the basis of disability by any person, organization, or private enterprise. And then we have Article 4.3, which I'm sure we've talked about before and is very significant. It's often cited, and that's the obligation in the development and implementation of legislation and policies to implement the present convention and in other decision-making processes concerning issues relating to persons with disabilities. States parties shall closely consult with and actively involve persons with disabilities, including children with disabilities, through their representative organizations. And I think we've actually talked a lot about that. It's important to know that this is an obligation under the convention, and if organizations first of all, the organizations, to be a representative organization, it must in effect be representing the constituency. So you should not have a service provider organization saying we represent people with psychosocial disabilities. You should not have a family organization saying we represent people with psychosocial disabilities. It should be people with psychosocial disabilities organizing themselves and deciding if they want to create organizations together with service providers or families or open to anybody who cares about the issue. But it really needs to be looked at whether an organization claiming to represent people with psychosocial disabilities actually is doing so. And to challenge, for instance, if the government or the National Disability Federation has in it an organization of service providers, and based on that they say, well, we already have you represented, and you come as an organization of people with psychosocial disabilities, and they say, well, sorry, but you can't be part of us because we already have this other organization representing you. That's a problem, and the state should not be accepting that. So often people with psychosocial disabilities and the user survivor organizations have to have some difficulty in advocating to actually be recognized and respected in their own right to represent themselves in disability and CRPD related consultations. And I think it varies a great deal in different countries, and I think it varies quite a bit, especially depending on if the country has a user survivor organization and had not had a lot of disability advocacy before the CRPD was adopted. Then I think that's the best position. That's the most likely situation where user survivor organizations will actually be completely accepted and respected. If there's no user survivor organization, it's difficult, and it's hard work for people to create them. And if in many countries where there are user survivor organizations, but they had not been part of the disability community previous to the CRPD being enacted, that's where I have seen a lot of obstacles. So then in Articles 5 through 30 related to specific rights and specific obligations, there's many things that that relate to process. We already discussed some of what the committee has said in jurisprudence under Articles 12 and 14. It would be really too extensive to try to go into all the details, but just be aware, if you're looking at what does the government actually have to do, what actions does the government have to take, there are many in that are contained in specific articles. So here, women with disabilities, states parties shall take all appropriate measures to ensure the full development, advancement, and empowerment of women for the purpose of guaranteeing them the exercise and enjoyment of the human rights and fundamental freedoms set out in the present convention. That really seems to bring in the whole scope of feminism, women's liberation, women's human rights as it pertains to women with disabilities. Um, so, and guaranteeing all of that, and guaranteeing that the state will take those measures, even if they haven't done it before, say under the CEDAW Convention. So that's just awareness raising, accessibility. There's it's just going to be necessary when you're looking at what you would like to see the government to do, or what you might ask the government to do, what to stimulate your thinking on it, and to stimulate your thinking on what you can ask the government to do, and also to find wording in the treaty that will say to the government, this is what you have to do. You can look at all the specific articles that pertain to the issue that you're concerned with, and the general articles and the committee's jurisprudence on it, to find what are the most salient things that you want. Also, I will say on Article 14 that we were discussing before, in the committee's recent general comment on Article 19, as I pointed out last week, they also include that states have an obligation to, and I don't have the wording in front of me now, but it's essentially to release individuals who are confined in mental health settings or in institutions. I can't recall the exact wording, but this is very significant because that it's, as far as it was said in concluding observations before, but I believe this is the first time that wording of the obligation to release has been included in general jurisprudence of the committee. And you can pick out pieces like that and point out to the government, these are your obligations now. So trying to, so we're focusing now on the process obligations, and that includes the general obligations related to the whole treaty and bringing it into national law, and also the specific obligations contained in these more specific articles. Then we go back to some obligations that have sometimes been characterized as specific process-oriented obligations in Articles 31 through 33. These are still at the national level. Article 31, data collection. I will only say on that the data collection, the way it's being proposed in the international community right now on disability, is not adequate to capture the enjoyment of human rights by people with psychosocial disabilities. This is a big problem and something worth looking into. It's not something I have been able to do much with, but I'm looking into. International cooperation, if your country is a donor country or a recipient country of international cooperation, or perhaps maybe both, you need to pay attention. You can have a chance to influence the way that international cooperation, whether it's activities or technical assistance or funding, needs to be implemented and carried out in a way that is in compliance with the CRPD. So they shouldn't be building more institutions. They shouldn't be providing technical assistance to make a new mental health law. Instead, you can be advocating to have technical assistance um, to create supports that comply with the CRPD, to develop laws that create an enforceable right to support that is non-coercive and that does away with coercion, that sort of thing. Then you have Article 33 on institutional mechanisms, a focal point for implementation, and one or more focal points for implementation within the government, in one or more independent monitoring mechanisms, DPO involvement in monitoring, and that should be national and international. And then also going back to the obligation of monitoring on the national level in Article 16.3 to monitor services and facilities that are designed for people with disabilities so as to prevent any form of abuse, violence, or exploitation. And that Article 3 monitoring is presumably what the committee was referring to in the guidelines on Article 14, that there's an obligation to monitor institutions and as well as other services for people with disabilities. And so it's important to understand, and it's important, if this is being done, to do advocacy to make sure that it's carried out in a way that actually does not perpetuate the values and principles and paradigm of institutionalization, but that instead is going to move us towards ending institutionalization. And really, I would say it absolutely would need to be carried out in a way that is helping people to get released from situations of what amounts to arbitrary detention, of situations where they're confined in any mental health facility, because that is a situation of arbitrary detention. It's a serious human rights violation, and I think it should be considered unacceptable for monitoring mechanisms, human rights monitoring mechanisms, to fail to adhere to that standard. And let's just take a look at that. I live in a country that hasn't ratified the CRPD, so it's hard for me to talk about these obligations. I'm aware of what's going on in different countries, but at this point, I just want to call them to your attention. So here is 33.1, which talks about designating one or more focal points within government for implementation, give due consideration to a coordination mechanism. And I will also point out that in an earlier non-binding instrument on disability, standard rules on equalization of opportunities for persons with disabilities, it provided for a coordination mechanism at the national level, and also that persons with disabilities should have considerable influence within that mechanism. So this doesn't specify that people with disabilities should be included in such a government or government-led entity, but it's certainly desirable, and you could advocate for that, or DPOs being included in such an entity along with governmental agencies. Here, 33.2, 33 that states parties shall, in accordance with their systems, maintain, strengthen, designate, or establish a framework including one or more independent mechanisms as appropriate to promote, protect, and monitor implementation, and that they shall take into account the principles relating to the status and functioning of national institutions for protection and promotion of human rights. That set of principles is called the Paris Principles. I've linked to that in the slides. And you should just know, essentially, states can designate one or more of such mechanisms. Some states are designating mechanisms at a federal level and then sub-federal levels. Some states have designated an existing national human rights institution. Others have chosen to designate or create some other entity. And the reference to the Paris Principles really is about the independence of such a monitoring mechanism and the potential powers that it may have. It doesn't say that these institutions must comply with the Paris Principles, but states parties shall take them into account. So there's some flexibility, and I would suggest that it's worth looking at the CRPD committee's jurisprudence if they're addressing this in concluding observations. It's not something I've paid a great deal of attention to, but there's also a thematic study by the Office of the High Commissioner for Human Rights. I think it was in 2010 that looked at national institutions and independent monitoring mechanisms in relation to the CRPD, basically that looked at Article 33 obligations. So that's worth looking at if you're concerned about how that's working or not working in your country. And here, civil society, in particular persons with disabilities and their representative organizations, shall be involved and participate fully in the monitoring process. And many states have established various consultative mechanisms, both for national and international monitoring processes with civil society. And we'll discuss the international monitoring shortly, but it's always worth looking at what are the opportunities for participation, but also looking at what's the impact of participating and how, your own priorities in terms of time and energy and effort. So if the state is having a consultation into because they're preparing a report to the CRPD committee, and they're asking DPOs for their input into it, you might want to participate in that. But if you haven't yet done your own shadow report, well, it could be an opportunity to start you off, to start looking at what are the broad areas of your advocacy, but make sure that you don't rely on that consultative process to get your issues out in the international reporting process. Make sure that you also do your own shadow report, because the government is not necessarily, and I would say probably not likely to really put forward the issues where you are disputing how well they've been complying with the convention. So that's just something to look at. Okay, so here I've had a slide, process and participation at the national level. Before we go to the international monitoring, what can DPOs get involved with? Can get involved with the focal points and anyone else in the government responsible for CRPD implementation, find out who they are, if they've been designated, seek them out, get to know them, establish some contact, and start a discussion about the issues you're concerned with. How are we going to actually move forward on implementation? Look at what are the actions that you know are contrary to the CRPD that government has taken or that government is taking. So if there is a mental health law that allows commitment and forced treatment, you can look at, okay, so what is the process to actually repeal this mental health law? Does it seem feasible to engage in litigation, to work with lawyers and see if a judge can declare this law unconstitutional or something like that? And look at if your government is creating a new mental health law that is, going to perpetuate practices contrary to the CRPD. That's a point where you should get involved, and you can be advocating against it, calling attention to how they are going in the wrong direction, and retrogression is an even stronger violation of their human rights once they're bound by the treaty to go backwards and make things worse, or I guess it maybe even if it doesn't make things worse, to perpetuate the violation. So there's an opportunity for political advocacy there, and to bring in, say, international mechanisms if that's possible. You can invite the special rapporteur on the rights of persons with disabilities, other special rapporteurs, members of the CRPD committee to come and give their opinion. Individual members could not speak for the whole committee, but their weight as international experts can be valuable. That sort of thing. Okay. Independent monitoring mechanism, National Human Rights Institution. Find out what are the ways to get involved with them. Find out what they're doing, and do they have a process of consultation? Can you work with them both, whether formally or informally or both, to how well educated, how well informed are they on the issues you're concerned about? Can you encourage them? Are they politically hesitant? Can you encourage them to go further? What can you do? Do you want to bring in international experts to meet with them, and that sort of thing? Civil society projects for litigation, law reform proposals, shadow reporting, complaints to international human rights mechanisms, various kinds of legal and political advocacy that you can do, and even awareness raising campaigns, and seeking out allies. You might want to develop a base of political support, educating people before you start a campaign formally in the legal or political arena, or that might be part of such a campaign. DPO advocacy, the user survivor movement sometimes has not wanted to constitute itself as a DPO, has not wanted to say we are people with disabilities for various reasons, often good reasons, but in order to participate in formal processes or even informal processes related to the CRPD, it's valuable to say we are people affected by this treaty. However you want to reconcile that your rights are protected, you can say we are people who are perceived as people with disabilities, or maybe it's in your country and in your context, it's completely uncontroversial, and the use of survivor movements has already embraced the social model of disability, and that's fine. Also, independent activists, even if say the user survivor organization in your country has not really gotten involved with human rights, and or if there's not an effective organization, or maybe there is no organization, even independent activists can begin somewhere, begin to raise awareness, begin to seek out other users and survivors, people with psychosocial disabilities who are like-minded, who are concerned about human rights. Seek out allies in any field who could help you. Make sure that the allies are not taking over. And that can be tricky sometimes, but even independent activists with good ideas, with strong ideas, especially now that we have a global movement and we have global jurisprudence and standards backing us up, there's a lot more room to make something happen. Okay, so international monitoring. Well, here I've put some general concepts or questions that gets raised. So what does it mean to say that international human rights treaties are law? Really, what does it mean to say that international law is law? What does it mean to say that the human rights treaties are international law? Can they be enforced? Is there a court somewhere that can take a state to court and say, you are violating this treaty and you're guilty? Enforcement of human rights treaties is limited. So at regional levels, you do have courts that are able to make binding decisions on whether states are complying with the CRPD. If you're in one of those regions, if your country is a state party to such a court, you have some opportunities, but then you have to really make sure whether those regional mechanisms are adhering to the CRPD standards. This has been a big struggle, especially in relation to the European Court of Human Rights, where they have not only their history of jurisprudence, but they have a provision in the European Convention on Human Rights that explicitly allows deprivation of liberty based on a person being of unsound mind, which is contrary to the CRPD. So there's there has been somewhat and needs to be an ongoing attention in relation to the European Court of Human Rights to persuade them to move towards the CRPD jurisprudence, because what they're doing is in effect perpetuating discrimination based on disability. So at the global level, there is no human rights court. The human rights treaty bodies do not function as a court, although the Human Rights Committee, which monitors the International Covenant on Civil and Political Rights, has declared that their decisions in individual cases are binding on states. And I would presume if theirs are, then the other treaty bodies' decisions should be also, but it's controversial, and there's nothing in the treaties that says that these decisions are formally, legally binding on states. So when you make a complaint or individual communication under the CRPD optional protocol, the CRPD committee will issue its views. It's also called a decision, and they will say, they will say that a state has violated such and such rights or has not. They may find in a particular case that some of the claims of violation are upheld and some of them aren't. They may find a case to be admissible or not admissible. It's a legal standard of determination that they're using, but it is not it's not considered fully an enforcement mechanism. They will encourage the state to implement their decision. They will follow up with the state if the state to ask whether the state has implemented their views in a particular case, but there is no mechanism to actually force the state to comply if they choose not to, or to accept the decision of the committee if the state just says no, we're not going to. But it is certainly something that the CRPD committee will follow up on with the state, and that civil society can use in their advocacy. I would assume this could be brought up in litigation to the extent that litigation is possible in a state party if the CRPD committee has issued views and the courts may be receptive to that. It's certainly something you'd want to bring up. So those I would characterize as quasi-judicial. It takes the form of adjudication. There's submissions by the person making the complaint and by the state party, and the committee is acting as an independent mechanism in that regard and rendering an impartial decision. So it takes the form of adjudication, but it is not considered a court, and it's just important to be aware of that. It's both its potential and power, the power of such a judgment of adjudication, even if it's not legally binding, can be useful, and its limitations. And these monitoring mechanisms, both under the optional protocol and the regular reporting process, are viewed in varying ways by different states. So, for instance, even the CRPD committee's general jurisprudence, like their general comments, some states will consider that if they are enacting legislation related to the CRPD, that they really need to take serious account of, say, general comment number 1, and study it closely if they are going to enact law reform on legal capacity. Other states might really take a position, what the committee says really means nothing to us. And that's a very disrespectful position, but there are states that will try to avoid taking account of what the committee says. So it's important to just try to get to know how these things are viewed in your state, both legally in a formal sense and also politically. How does your state generally think about human rights treaties? I know in the United States there's often quite a double standard of wanting to hold other countries to human rights obligations that the US considers important for them, but not really wanting to hold itself accountable, or to allow other countries to hold it accountable, or to allow international expert bodies to hold it accountable. So, and then there are other countries that may be the reverse. They may not necessarily get involved with what other countries are doing, but they may have a much more serious assessment of their own human rights and how and how much they have to really take account of what of what the international community thinks about their human rights record. General comment, again, are not legally binding in the same way that the treaty itself is. There's nothing in the treaty itself that says that states have to comply with the treaty body's interpretation in a general comment or in the decisions or concluding observations. But it's been pointed out that the general comments represent a deliberative process of international experts in the subject matter. Usually it represents a consultation, an open consultation where they're able to consider all the different viewpoints presented to them from any perspective, and it's their considered assessment of what the interpretation of the treaty is, considering these various submissions. And they are in the standpoint of receiving all the states parties' reports, all the communications under the optional protocol. And so they have the best overview of what is going on in relation to the treaty. What are the issues where civil society, people with disabilities who are the beneficiaries of the treaty, are complaining of injustice? They are in a good position to determine from this very broad perspective, where they have an obligation of impartiality and where they're independent experts, to issue the most authoritative interpretation, also taking into account that human rights are considered to be universal, and the meaning of a human rights obligation under the CRPD should be the same for all countries. So it's really the committee that is the only body that's in a position to make such an interpretation from an impartial position. And even the Conference of States Parties, in a sense, if they would, the Conference of States Parties has been very careful not to interfere with the role of the committee, not to usurp the role of the committee, because they understand that it's very important to have this mechanism of international experts actually monitoring the states. And so the states as a body want to respect that, and that shows the respect they're giving to the committee as a whole. So that those are various arguments that can be brought in favor of persuading your state that the general comments should be taken very seriously and should be understood to reflect an authoritative interpretation of the convention, while acknowledging that there's, that if they say, well, we're not required to, and that's that, there's nothing legally binding on them in that regard. And then there's the concluding observation on state party reports. I think that's already pretty much been covered. That's the committee's view. And again, it should be taken as authoritative. They're the impartial, independent experts. And, it remains a matter of political advocacy and the approach taken in particular states, how much weight they'll be given. So we can look at the CRPD, what the CRPD text says on international monitoring. Article 34 establishes the Committee on the Rights of Persons with Disabilities, talks about how many members it have. At the present time, we've had 18 members for a while now, and that the members shall serve in their personal capacity and shall be of high moral standing and recognized competence and experience in the field covered by the present convention. And I recall in the negotiations, there was among the DPOs, there was some concern what is going to be understood as the field. And of course, it has to be the human rights of people with disabilities. We were concerned about not wanting to have people coming in as experts because they are, say, rehabilitation counselors or mental health providers. And in fact, there's no way of preventing whatever kind of interpretation of who is claiming to be an expert in the field covered by the convention. There's various DPOs get involved. I know the International Disability Alliance had gotten involved. I'm not sure if they still are in assessing, making known, not necessarily assessing, but issuing some questionnaires and encouraging candidates for the committee to make their views known on various issues of importance. And so DPOs can get involved and encourage their own states to vote for, to nominate and to elect committee members who are in fact well qualified as experts in the human rights of people with disabilities. Also, it's important here, the next provision here in Article 34, members shall be elected, consideration being given to equitable geographical distribution, representation of the different forms of civilization and the principal legal systems, balanced gender representation, and participation of experts with disabilities. So that all has to be taken into consideration. And in the next period of time, I think it's going to be important again for organizations of people with psychosocial disabilities and independent experts and activists to consider if there's anyone who they would want to propose that their state nominate to the committee, because for a while we had there are three former committee members who are persons with psychosocial disabilities, but currently no one on the committee is. And the committee has been doing very well in maintaining its standards on the issues we're concerned with, but it's always valuable to have someone on the committee with the lived experience who can bring that the lived experience combined with the subject matter expertise, who can really play a leading role on these issues. And it would be valuable to have more than one at a time. We have at some points in the committee had I don't know if it was ever all three at one time, but I believe we have had at least two, and that's valuable. There should always be, it doesn't say balanced representation of the different disability groups, but there should be an attempt to achieve a greater balance than there has been. Also, as you may know, right now there is no balance of gender representation. There's one woman and 17 men on the committee, and there's a big effort to try and to improve that in the next elections. This is all, again, about the process of election and their terms. So you can take a look at those materials. You can take a look at the committee's rules of procedure and working methods. And I've noted the working methods is the most concrete description of how the committee works. See also the guidelines for DPO participation and more process materials on the committee's website. I'm going to also just say something about the reporting. You see Article 35. This is the actual obligation of periodic reporting by states parties written into the text. There has to be an initial report. I believe it's within 2 years. There's a backlog now in the committee. And then subsequent reports, the committee has now started on the second round of reports for a number of states parties. And they've instituted a process called list of issues prior to reporting to to be able to sorry, I was looking to allow for a more focused approach, and instead of the state party making a report and then getting follow-up list of issues and then responding to them, instead, since there's already been an initial report, there can be some submissions from civil society drawing the committee's attention to issues that they might want to ask questions about, and then the committee issues a list of issues prior to reporting, so the state can really focus on what the committee wants to know about. Here again, there's in the state party reporting to the committee, they are invited to give due consideration to the provision in Article 4.3, which is addressing close consultation of DPOs. Here's Article 36 deals with the committee's consideration of reports, and they can transmit requests to various UN bodies and other competent bodies to address technical advice or to address needs for technical advice or assistance. And in the negotiation process, it was discussed that this phrase of other competent bodies could include civil society organizations. And I'm not aware of that actually having been acted on, but it's something that, you know, to the extent that civil society organizations have relevant expertise, especially DPOs, they should make the committee aware of this and of their availability to serve in this manner. And, you know, of course, the committee would need to vet them and ensure that it's actually what the expertise is being volunteered is actually in line with the committee's own views and appropriate to the circumstances. Cooperation between the states parties and the committee, relationship of the committee with other bodies. Again, here there's, well, yeah, that the committee may invite the specialized agencies and other competent bodies as it may consider appropriate to provide expert advice. This there's nothing in the text of the treaty itself that requires the committee to consult with civil society, except that this other competent bodies is usually understood to be the, you know, a way of referring or providing within the treaty for the participation of NGOs. And the committee's practice and the practice of other treaty bodies in the UN system has clearly been to be very welcoming of NGOs, and with the CRPD committee to prioritize the participation and consultation with DPOs in particular, and really with all NGOs, but giving priority to DPOs, as you can see in their guidelines and the guidance that the committee issues to civil society prior to each session. committee has to make annual reports. Here in Article 40 is the provision for the Conference of States Parties to take place. And other human rights treaties have a Conference of States Parties, but their Conference of States Parties is for the purpose of electing members to the electing members to the Treaty Monitoring Committee. The CRPD has this innovation of a conference to consider any matter with regard to implementation that was proposed in the negotiations. As I recall, it was really being promoted by the Landmine Survivors Network, which had experience with the Mine Ban Treaty and how valuable it was to have meetings of states parties where they would basically put on a big conference to different states, and NGOs would promote good initiatives. And so that's what our Conference of States Parties on the CRPD has come to be. And it's very worthwhile if you can get yourself to New York, if you have a project that you want other people to know about, if you have an issue you want to draw to the attention of everybody concerned with the CRPD, states, civil society, the committee, other human rights mechanisms, because sometimes there might be other human rights mechanisms attending also. It's a place. Think about putting on a side event at the Conference of States Parties. It can be a very big, overwhelming experience, but it can also be worthwhile also to see what other people are doing. Oh, and also there's the International Disability Alliance for the past couple of years, I believe, has coordinated a civil society coordination mechanism to advocate in relation to the program of the Conference of States Parties, because there's an official program as well as side events that can be put on by states, UN agencies, or civil society, or a combination. There's an official program that is determined by the Bureau of States Parties, which is elected on a rotating basis and is composed of states from each of 5 regions. So there is this civil society coordination mechanism, and it would always be announced on the email list of the IDA CRPD forum, IDA underscore CRPD underscore forum, I believe, at yahoogroups.com. So, okay, I also, and then there's the optional protocol, communications, and the inquiry procedure. I don't think I'm going to go into those in detail. I think I've discussed enough about the communications. The inquiry procedure, they've done one so far addressing austerity measures and their impact on people with disabilities in the UK. There's a report on that that's worth looking at to get an idea of what the committee can do and how it might deal with an issue that's presented of widespread impact on people with disabilities in a particular country. Okay, I wanted to call your attention. Oh, where do I have it now? Yeah, to the committee's guidelines on periodic reporting. The most recent one that was issued that was specifically trying to address the simplified reporting procedures, but it really is meant to cover, I believe, all of the current human rights, all of the current state party reporting. So this is very useful to look at if you're preparing a shadow report. And a colleague was trying to find it recently on the CRPD committee's website, and neither she nor I could actually find where it was linked on the website. So I think we need to figure that out, but I was able to find a public link for it, and I believe that it is the current version of what the CRPD committee is using as reporting guidelines. It was adopted in September 2016. So I would just want to flag that for your attention. I think I should try to post that on the course website, and you can remind me if I forget about that, because it's it's more the previous ones, reporting guidelines, were adopted in 2009, and the committee has done a lot of work since then. So this represents this would be taking into account of the general comments and the Article 14 guidelines and the committee's experience with reporting so far. Okay. Shadow reporting, I think I've talked a lot about that in the context of the whole lecture today, and I use the term shadow reporting, which is the word I originally learned for it. You will also hear the term alternative report, parallel report, civil society report, or NGO report. Some people would make differences in meaning between them. I would consider them as all meaning essentially the same thing. It's that when the CRPD committee is considering a state party's report, it's useful for them to have the information from civil society, especially from DPOs in a country, to let them know a perspective from people with disabilities, from civil society, on how well the state party is implementing its obligations, to call attention to areas where human rights are being violated, where the state party hasn't done everything that it might be doing. And the CRPD committee and other treaty bodies very much welcome these civil society reports. So I would say that's the main shadow report. You want to do a report that there's many ways to do a shadow report. You can focus on one or two very important issues. You can do a comprehensive report. You can do a kind of human rights survey among people with psychosocial disabilities to find out what are the overall concerns they're experiencing. And you can join with other DPOs and other civil society organizations to create one joint shadow report. It's not required to join together, but it tends to be strongly encouraged. I have always said I think it's important for user survivor organizations to make a very careful assessment of how much influence they are going to have in a joint report. So far, what seems to be the best practice for user survivor, people with psychosocial disability organizations, is to do a combination, to join in a joint report to make sure your issues are included. If somebody is only going to read one report and they read the joint one, you want your issues to be included in there, and you want them to be dealt with properly, not in some random way by people who don't know the issue as well as you do. You also might find, I think it's getting less so now, but especially in the beginning, it was common to find hostility among other DPOs and civil society organizations, to the extent where you might have to really fight to say that the mental health law is violating the CRPD. Now, I think the committee's jurisprudence has been clear enough that, more organizations in the general disability community and human rights community will be accepting that premise. But you need to check and determine carefully if you want to join with them, if you want to have your own report, if you want to do both. And usually it seems to me that most organizations find that it's to their advantage to do both, because in your own report you'll go into a lot more detail, and committee members who are especially interested in the issues you're bringing up will have the opportunity to really understand them better from your separate report than they can from a joint report where you're not going to get as much space. So I think I was planning to talk a little more about that next time, but I will say with the shadow reporting, it's important also to be aware of all the stages when you can get involved. So if the state hasn't done an initial, if the state is still in its first reporting cycle, there will be a list of issues. If it's in a second reporting cycle and the state has accepted the simplified reporting procedure, there will be a list of issues prior to reporting. So find out how you can find out when the next reporting cycle is going to be, find out when is going to be the next opportunity for you to have input into these lists of issues. That's going to be very important, especially with the list of issues prior to reporting. It draws the committee's attention to areas where they might ask particular, specific, probing questions of your country on issues of concern to you. I think it's often valuable for that kind of, especially for that stage in the list of issues, to make sure that you highlight the issues that are really a priority for you, and not necessarily to just put in questions related to people with psychosocial disabilities and their enjoyment of human rights under every single article of the convention without prioritizing. You can indicate those issues under every article if you want to, but make sure that you draw the committee's attention to the things that are most important to you, that they can pick up specifically if they want to address the issues that are most pressing to people with psychosocial disabilities in your country. It's also valuable not only to submit these materials in writing, but to go to Geneva to meet with the committee members, to find out who are the committee members, who is going to be the country rapporteur on leading the questioning and the writing of the concluding observations for your country, who are going to be the committee members that are dealing with the specific articles of the convention that are the greatest priority for you, either in general or in relation to your specific country, and get to know them. You can have, there's opportunities to participate formally in the civil society briefings at both of these stages. When they're doing a list of issues and when they're doing the country report, those briefings are private. The government officials are not allowed in the room, and they're kept confidential so that there is less, to avoid the potential for government retaliation against civil society. I believe that submissions by NGOs could also be anonymous or not, or could be unpublished on the website. I know that's the case in relation to general submissions, and that's something to check on. If there's a concern about government retaliation, there's always some way to protect yourself. And okay, so those are important things to look into, to be prepared, to plan ahead of time, to look at the different parts of the time frame when you can get involved in the reporting process, and to make every effort to go to Geneva. Many DPOs try to travel to Geneva to get a feel, to get a sense of how the committee works. If you haven't been there, even before your committee is having anything go, even before your country has anything going on, so you can introduce yourself, maybe meet with committee members who are interested in your issues. Just learn a little bit more about how it works. Of course, it costs money to go to Geneva, and if you are able to get the funding, it's something that funders should be interested in supporting. Be aware of other treaty bodies that could be useful to you. Again, this is going to depend on how much effort and energy and resources you can put into shadow reporting as a whole. If you only have limited effort, limited resources or energy, and your country has ratified the CRPD, I think it's always going to be the best bet to you to report under the CRPD rather than some other treaty body. If your country hasn't ratified the CRPD, think about, which treaty body might be the best use of your time. In the U.S., the U.S. has ratified the Covenant on Civil and Political Rights, the Convention Against Torture, and the Convention on the Elimination of Racial Discrimination. Now, all of those are relevant, but so far, the Human Rights Committee dealing with the Covenant on Civil and Political Rights and the Committee Against Torture have not been all that receptive to giving strong recommendations of the kind that I would want to see. Clear recommendation to abolish forced treatment and forced hospitalization. That would be my priority. And so my priority as an activist dealing with the United States right now, if I have limited energy and resources for shadow reporting, is going to be to address myself to CERD and to address the ways and the circumstances that people of color in this country are being specifically and detrimentally impacted by forced psychiatry and by related human rights violations. So that's something that needs to be addressed in every particular country. One of my colleagues in Norway has been very systematically and diligently doing shadow reporting, I believe, to every treaty body that the state is a party to, and building up a body of useful concluding observations. And sometimes you don't get the concluding observations that you want, and then you say, well, they're still obligated under the CRPD, and the CRPD clearly requires abolition of these coercive practices. And the fact that some other treaty body might excuse them under that treaty, it doesn't mean that they're going to be excused by the CRPD. So there's many different ways to deal with this. Look at the Universal Periodic Review in the Human Rights Council. I don't think I can go into detail on that. It's a process where you're dealing with states and asking other states to ask questions and make recommendations to your country. Look at other complaints mechanisms, including special procedures of the Human Rights Council, regional human rights courts and commissions. Regarding special procedures, the Working Group on Arbitrary Detention is something that I would really want to highlight now, because they are starting to become very active on the issues of on the CRPD issues related to detention in mental health facilities being arbitrary detention. And because they have unique among all the special procedures, they also issue written published decisions. So especially if your country has not ratified the CRPD optional protocol, and you think it would be valuable in a particular case where somebody is being involuntarily held in a mental health facility and or involuntarily treated, you might want to consider submitting their case to the Working Group on Arbitrary Detention, which has the power to issue a written published decision. The other special procedures, they can issue an urgent appeal, they can publicize their recommendations to the committee, but it doesn't have the character of a decision. As so what the Working Group on Arbitrary Detention does also has more of an adjudicatory character because it's characterized as a decision, and it would be understood as closer to the workings of a court than the recommendations that another kind of special procedure like the Special Rapporteur on the Rights of Persons with Disabilities might issue. So I think I've talked about what the working group has done. They did an urgent appeal in a Norwegian case together with two special rapporteurs. I don't know if they've said publicly whether they're going to put this through the usual procedure and also issue a decision. It would certainly be valuable if they do. And they also did issue a report on a country visit to the United States recently where they had the sentence that involuntary treatment is prohibited unequivocally. And I think that is, I think, involuntary hospitalization and involuntary treatment. Can't remember the details, but that is very valuable for our advocacy. Global advocacy by civil society is another important way to get involved. So anybody, DPOs at the national level, any user survivor organizations, which are of course DPOs, independent activists, academics, any civil society organization can participate when the committee is holding a day of general discussion, a consultation on a general comment, when special rapporteurs or the Office of the High Commissioner for Human Rights are asking are holding a consultation, asking for submissions on a particular report they're going to be writing. It's useful to become aware of these different things. If you join that IDA CRPD forum email list, there are many things that will come across that list. And the Office of the High Commissioner for Human Rights also has a notification email list for civil society that is worthwhile to subscribe to learn about some consultations as well. You can do side events when the CRPD committee is meeting. You can do a thematic briefing. You need to apply, and there may be limited space, so the committee will have to decide, when and whether to schedule the thematic briefing that you want to address. And if you attend the Human Rights Council, there's various days and panels that go on there. So and the Conference of States Parties, of course. And then there are sometimes expert meetings that I guess it could be held by one or another special rapporteur. If you have expertise in particular areas related to the convention and its implementation, it's good to make these human rights, these United Nations mandate holders aware of your expertise, so that they might think of calling on you if they hold an expert consultation on an issue that where you can be supportive. Okay, so I think I've come to the end of the slides, and I didn't actually get what I was wanting to do, but I'm going to share this briefly. Okay, I'm going to just start from the beginning. And this is really for people who are not familiar with the work of the committee or how the human rights reporting particularly works, because the reporting is going to be the thing that user survivor activists are more likely to be able to get involved in, rather than the individual communications and other such things. So you go to the committee's website. You can find that easily on a Google search, Committee on the Rights of Persons with Disabilities. This is what it looks like. Then on the right-hand side here, you click on Sessions. This will give you links for every session of the committee and every pre-sessional working group. It shows which countries are being addressed, and usually it will say, hopefully accurately, which process is being addressed. Sometimes it's a little bit inaccurate, but the committee sessions are numbered. So this is, say, the 17th, the 18th session. The 19th session is coming up in February and March of February through March of 2018. The pre-sessional working groups are numbered separately. So you have 8 pre-sessional working group, 9 pre-sessional working group. That is not all the members of the committee, but only a limited number. And that I believe is basically for the list. That's for the list of issues generally, as far as I understand. And then to prepare lists of issues for the countries that are named in those pre-sessional working groups. So, and you'll see that followed up. So here you have in the pre-sessional working group Haiti, and then Haiti in the 19th session. That's really when the state parties report is being considered. So if we want to go to any of these sessions, you can find all the written materials that are available. So there's general documentation, which includes various statements in the opening session by UN bodies and also by civil society. The summary records of the opening and the closing meeting, a link to the webcast. Those are all very useful. Sometimes there might be something that your state party said in a webcast that you can use in your advocacy. This was the case in one situation that I was able to draw attention to, and to support an activist in a particular country. And then you have consideration of state reports. Here you will have all the materials on a particular state that's related to that session. So the first is always going to be the civil society report and their Common Core document. States are now required to to submit a a document that's related to general issues in the state party that apply to all the human rights treaties. So that's included here as well. And you see here Armenia's was from 2014. Okay. Here you have the next, you have the list of issues. So this would be, this is we're looking at a session where the committee is considering the state's report, so they have already issued their list of issues, and that's where you find it. Then you have the state's reply to the list of issues. Then we have three categories here actually of information from civil society organizations. So this might be information submitted before there was any the first information that was submitted. Then there's information submitted for the list of issues and information submitted for the session where the state party is under review. And you have all those provided separately, and sometimes an organization will make submissions at every stage of the process. So here you have the Helsinki Foundation, Helsinki Citizens Assembly, Vanadzor, and Open Society making a submission for the list of issues, and then Helsinki Citizens Assembly, Vanadzor making their alternative report. So they did both there. List of delegations participants, that's the state. Who did the state send? Did they send high-level officials? On the ministry level, did they include civil society experts? Did they include the most relevant people from the various ministries who could speak to the issues? That you may want to check that out if your country has already reported and you want to see what they actually did in that, and you weren't involved at that time, or you just want to check it, or you're interested in a country other than your own, then the NHRI, if the NHRI has made a submission, it will be there. Then opening and or closing remarks by the state delegation. Then here you will have the concluding observations and the summary records for those sessions. The summary records are of the committee's question, the state's presentation, the committee's questions, and the state's answers to those questions. Those are public. If you're in Geneva, you can attend them, and they are being also webcast. There are no official records or webcasting of the civil society briefings for the reasons of confidentiality. So this is the kind of thing that you would expect to find in relation to any state party. Sometimes you may only want the concluding observations, and you just go right for that. Okay, I want to see the concluding observations for Bosnia and Herzegovina for the most recent session of the CRPD committee. Here they are. Here's Canada. I want to see if there's a user survivor organization, and here that submitted information, and here you have Med Canada Shadow Report submitted information for the session, and Med Canada Shadow Report Group also submitted information for the list of issues. So you can tailor your research on here to what you actually want to look at. You can also see up here, these are for future sessions. These are states that have submitted their reports but not yet been scheduled. If you only want to check out the concluding observations, you can just go here to the page on concluding observations. You can do a search for the particular country you're looking for. You can do here if you're doing a search, you're in the CRPD's page, so you're going to want to be looking at the CRPD. But you can search for, if say you want, or maybe it will just give you, yeah, we're just doing the CRPD here. So you want to find the concluding observations for Argentina, you can just find that. So this is just to give you an indication of various ways to find the information that you might need on the CRPD committee's website. And just so here's where those other guidelines are. The guidelines on periodic reporting, including under the simplified reporting procedure. So that's in these basic documents and guidelines on independent monitoring frameworks. I was wondering about that because that was a new link. And the I believe, see, the general comments and the guidelines on Article 14 are separately under, you have general comments and the guidelines on Article 14. So we're coming to the end of the time. If people have any questions or comments, you're welcome to write that in the chat. And if you wish and if you prefer, I could give you the microphone. Just remember that we're recording, and I would like to make it public, so you can decide if you would like. The chats aren't public, so you can write anything in the chat if you like, or you can ask to speak if you have a question or comment. Go ahead, please, with the question. Do you want the mic or do you want to write in the chat? Okay, you're going to write in the chat, so I'll wait. Give you time to do that. And meanwhile, I'm going to just bring up the course website so I can talk a little bit about the assignment for this segment after we're okay. Thank you for the comment saying that it's clear information about the work of the committee and opportunities for advocacy. Much appreciated. And I know there's another question coming up. Okay, here's the question. How do we ensure that data collection that takes place about, say, use of restraints in psychiatric institutions are not the whitewashed statistics provided by the institution? For instance, professionals may list that they restrained someone for 6 hours, but in reality, the person was restrained for 12 hours. I think that's something that you could address in shadow reporting. I mean, I would certainly encourage that if that's, I mean, you could, it depends in what situation it becomes relevant. So if it's something, say, that they are doing, that they are saying is part of their data collection obligation under Article 31, and you want to contest that specifically, if that's a specific, pretty much routine practice, and you can document it, I think you could call attention to that. You could also just document it. You know, it's an issue that would come up under Article 15. The committee has pretty consistently now been dealing with the issue of restraint under Article 15, freedom from torture, cruel, inhuman, or degrading treatment or punishment. And, if they're trying to minimize the extent of their violation, and that it's worse either in a particular case that's of particular concern or generally, so you would call attention to that. And um, I think if you're concerned about the accuracy of the statistics, you want to make sure they're accurate, you can try to get involved with that at the national level. How are the statistics being collected? I think that it's probably in some ways a good idea to start by thinking about what kind of statistics do you need and want. What is it that you want to use statistics for? What do you want to use them? Excuse me. What do you want to use them for? Rather than what does the state party want to use statistics for? So, in that instance, I would want to know about restraints. I think it's important to understand the level of egregiousness. It's certainly worse to keep someone in the restraints for 12 rather than 6 hours, but the restraints, any of the use of restraint is going to be a violation. And, in the context of a mental health facility, any use of restraints should be clearly understood to be a violation of the CRPD. So you want to make sure that these statistics are accurate, that they're not minimizing, but I think the only way to contest it is by independent evidence. So the person who is being held in restraint, whatever independent evidence you can come up with to show that their statistics aren't accurate, and if there's a practice of whitewashing, maybe if there's the National Human Rights Institution or independent monitoring mechanism could get involved and check the practices. Maybe an entity, a monitoring mechanism that monitors institutions can go and make surprise visits and try and learn more of what is not being disclosed. Organizations such as Human Rights Watch, or if a DPO can get involved and do their own human rights report, their own human rights investigation and monitoring of that kind, civil society human rights monitoring, that's something that could be worth doing. So, I'm not. I think independent a monitoring mechanism. I believe the question is: do independent organizations have the ability to make surprise visits? If you're an NGO, I would say no. I don't think there's any way an NGO could simply make a surprise visit and unless the institution wanted to welcome them. If your country has ratified the OPCAT, the Optional Protocol to the Convention Against Torture, I believe that the mechanisms required to be set up under the OPCAT, the national mechanisms to prevent torture, should have the ability to make surprise visits. And again, it depends on how diligently and correctly the state is implementing that and enforcing it, whether such mechanisms would actually have that power, and that the institutions would have to comply. So, and then if your state hasn't ratified the OPCAT, then I think you could take a look at what the CRPD committee has said in its jurisprudence about, have they mentioned that the monitoring under Article 16.3, or monitoring of institutions, should have the ability to make surprise visits. I don't recall this, but how have they have under Article 15 mentioned, I believe, the OPCAT in some way or another many times. So how have they done that? Is there a way to interpret that as meaning that the mechanisms that monitor institutions should have the ability to make surprise visits, as an obligation under the CRPD, even if the country hasn't ratified the OPCAT? Are we including some of those principles in some sense? So, yeah, I think there's if the institutions have made themselves inaccessible to observation, you might want to draw attention to that issue, draw attention to human rights violations that you know are existing and the inaccessibility. Make a submission in that regard to any of the special procedures that are relevant, and take a look at which of the special procedures of the Human Rights Council could be relevant, might want to get involved. So, and they can raise questions with the government to ask them, this is what a reliable, credible NGO has said to us, and this is the information they've given, this is the evidence they've given, and you're making yourselves inaccessible, you are carrying out violations behind closed doors. How do you respond to that? How can you should, that's basically asking them to respond, and then try to get to see if they will make a recommendation for something to change. And again, you have to think, what is the priority? What are the combinations of things that, if the government would do them differently, would really make a difference, and what is a lesser priority? So I don't know if there's any follow-up questions, or is okay. Comment, we don't have an NHRI. Would DRI be able to do it? Or Human Rights Watch? Those are NGOs, and they would need to get the cooperation of the government. And I suppose of the specific institutions in order to visit them. Even for the special procedures mechanisms to visit a country, they have to get the agreement of the government to welcome them for a visit, to welcome them, into visiting. Say, when the Working Group on Arbitrary Detention came, they had to get the agreement of the United States to come. And I'm pretty sure that they had to work with individual places of detention. I think that they weren't being allowed access to Guantanamo, and so there were limitations being placed, and so they didn't visit, because they have a standard of what they need in order to carry out an effective impartial visit, and it wasn't being offered to them. So, whether it's a user survivor organization or another kind of NGO, there's information, there's investigation that can be done, even if they don't allow the organization to visit institutions. Also, a human rights reporting organization can report about that. You report about whatever the responses are. So, you could seek the help of organizations with that kind of experience, and ask them what they do in this kind of situation. So, okay. All right, we're going to end here. We've gone over time, and I very much appreciate the participation of those of you who attended. I did want to call attention to the assignment for this segment, but I think that I'm actually going to hold off on this and discuss the assignment next time, because most people have not gotten current with the assignments yet, and I would like to give people a little bit more opportunity for that before talking about this one, which is a little different. So, and I may actually also revise some of what's on the website for this assignment. So I will, for those of you listening now and those who will listen to the recording, I will be talking about the assignment for these more general segments the next time. I will also invite you to think about what you would find helpful to address in segment number 8, because I've left segment number 8 as optional. And so there could be an opportunity to go into more depth about something we've discussed that participants in the class this time are interested in, or something that we haven't addressed, or some particular angle that people are interested in. So I'll post that in an email also, and invite you to think about it. Okay, thank you for participating, and I'm going to end now. Goodbye. See you next time.